Good morning and welcome to the Renewables Grid Initiative webinar dedicated to the overriding public interest, where today we will dive into the legal perspective on the application of the IROPI, or overriding public interest, and we will also discuss about the related and possible risks. My name is Cristina Signoli. I'm the Renewables Grid Initiative Program Manager for Offshore Energy and Nature, and I will be the moderator today. Before we dive into the presentation and discussion, I would like to share with you some very simple housekeeping rules. So first of all, we are recording this webinar, and the registration will be available only to the participants and will be shared afterwards. We ask you to kindly rename yourself by typing your name and the name of your organization. This will allow a better conversation after the presentation. As you're all very familiar now, please mute yourself unless you're speaking. We will be using the video actually after the presentation, and I will remind you about this. And with regards to your questions, you can raise your hand using the reactions button, and I will then open the floor and call your name in order to ask the question. You can also use the chat, but we would kindly ask you to limit the conversation on the chat, since you will be given the chance then to ask questions directly to the presenter later. For those of you who are not familiar with the Renewables Grid Initiative, just let me share you a couple of information. The Renewables Grid Initiative is a European association based in Berlin. It has been founded more than 12 years ago, actually. We are very unique collaborations of and transmission system operators and NGOs who decided to work together in order to enable the growth of renewables and to work together in order to shape the future energy system. We have a very good coverage of all European member states, and we are here today to introduce you to a topic that is related to renewables growth. Before introducing you the presenter, I would like to give you a couple of information about the contents and why we decided actually to tackle this topic. So the urgency to speed up the deployment of renewables energy and the grid is now confirmed by also the current geopolitical situation, so that the war on Ukraine made it clear that we need to become energy independent, and renewables are a way forward. The communication published in March by the European Commission, the RePowerEU, actually confirmed this, but also make the reference to the principle of overriding public interest in order to allow the needed energy infrastructure to be in place and on time. Our concern is that by speeding up deployment, which is absolutely needed, that the environmental part is not taken into due consideration. So that today we wanted to present to you, first of all, the theoretical and legal aspects related to the principle, in particular related to the conservation and environmental aspects. Of course, we are aware that the overriding public interest actually has many other fields of applications, but today we will focus on this. So in order to do that, let me introduce you the very esteemed expert that we have today with us, and his name is Harm Dotinga. Harm is a senior lawyer at Vogelbescherming Nederland, so BirdLife Netherlands, and he's responsible for the legal activities related to the protection of wild birds and their habitats at national, but also at international level. Harm has contributed to many initiatives, and those initiatives have focused on nature-inclusive energy transition on land and at sea. And among those, he also contributed to the development and implementation of the Dutch North Sea Agreement, which is an agreement that aims to simultaneously facilitate the offshore energy, nature, and food transition. Last but not least, Harm has also been working in the past and for many years as a university lecturer at the School of Law at the Utrecht University, and also as a senior research associate at the Netherlands Institute for the Law of the Sea. So I would like to pass the floor to Harm, and please, Harm, the floor is yours.
Thank you, Christina. Good morning, everyone. And thank you for this very good introduction. I am a former lecturer, so I'm no longer a lecturer. It seemed like the slide suggested that I'm still a lecturer at Utrecht University, but I stopped doing that when I started working, well, for full-time really for BirdLife. I used to have 2 jobs, but now I just work for BirdLife Netherlands on legal issues, as mentioned. And I have the privilege to tell you a little bit about the imperative reasons of overriding public interest and its relation to the nature directives. So the perspective is nature conservation. And that's the focus of my presentation. The outline, I'll just start with a brief background on why we are discussing this. Then I say a little bit about the nature directives themselves for everyone who is not that informed about the nature directives, and then go into the actual topic of IROPI, imperative reasons of overriding public interest under Natura 2000 rules, and then move on to the same issue under the species protection rules, because that's where this is relevant in the directives. I will illustrate this also with the Dutch approach that is followed in relation to the energy transition in the North Sea, with which I have considerable experience. In part because I participated in the negotiations of this North Sea agreement, which, as Christina mentioned, facilitates not just the energy transition, but also the nature transition and the food transition in the North Sea at the same time, simultaneously. I guess that's one of the messages that I want to bring to you, that you cannot see the energy transition in isolation. There's also a biodiversity crisis we have to address. We need to make a transition there as well and make sure that these two are mutually compatible and reinforce each other. And I will end with some conclusions. Just to start with the background, the reason why we are discussing this is this communication from the Commission, the RePowerEU communication, that says, among others, that the Commission calls on member states to ensure that planning, construction, operation of plants for the production of energy from renewable resources, the connection to the grid, and the related grid itself are considered as being in the overriding public interest and in the interest of public safety, and qualify for the most favorable procedure available under planning and permitting procedures. So one of the things is, if you qualify this as overriding public interest, then the procedures that may apply can be speeded up. The question is whether that also applies to nature conservation legislation. And so the questions that I will try to answer is, first of all, what is the significance of qualifying RES and electricity grids as imperative reasons of overriding public interest and the interest of public safety under the EU nature directives? So hereafter I will refer to just simply to IROPI under the nature directives. Does it speed up permit procedures? And is it a way to sidestep planning and assessment requirements? I won't give the answer yet, but yeah, I will leave that till the end. Just to start with the nature directives themselves. When we talk about the nature directive, we're talking about the birds directive, which aims to conserve all species of naturally occurring wild birds and their habitats through both area protection, protected areas, and species protection. And that applies both to the land territory and the marine environments. So it's also very relevant for offshore birds, as well as migratory birds crossing the sea during migration. The Habitats Directive is the counterpart of the Birds Directive. It deals with other species of wild fauna and flora and natural habitats, and its aim is to maintain or restore at favorable conservation status these habitats and species. Also through area protection, Natura 2000, and species protection. So the two directives are complementary, and in fact they are very much in unison with each other, because Natura 2000 covers both areas designated under the Habitats Directive as well as areas designated under the Birds Directive. And also the species protection provisions are complementary. And in fact, the objective for birds is very similar to what it is in the Habitats Directive, aiming to maintain or restore at favorable conservation status those species and habitats. There is a new nature restoration law coming up. It should have been presented already, but that has been postponed a little bit. I understand we can expect it maybe in June. And that directive is complementary to the Birds and Habitats Directive. I won't go into that today, but just focus on the existing law, so the Birds and Habitats Directives themselves. IROPI under the Habitats Directive, it's actually a term that's only used in the Habitats Directive. In the context of Natura 2000, it's part of the rules, the protection rules that is contained in Article 6. And IROPI is part of the exception that can be made for plans and projects that have negative effects on species and or habitats in Natura 2000 sites. And it is similar in the context of the species protection rules, because IROPI is also part of the exception that can be made from the prohibition that apply to individuals of a protected species. Whereas Natura 2000 rules apply to Natura 2000 sites and activities that may have an impact on those, the species protection rules apply wherever the birds or other protected species occur. So those prohibitions are very relevant for wind farms, irrespective of their location in or near Natura 2000 sites. They apply wherever the birds occur. The Birds Directive doesn't refer to IROPI, but Article 6 also applies to Natura 2000 sites designated for birds. So that's important to understand, that Article 6 has an application that extends to all Natura 2000 sites and not just sites designated under the Habitats Directive. And when we get to the substance for Natura 2000, one of the key provisions is Article 6.3 of the Habitats Directive, and that's very relevant for renewable energy projects, because it requires that all plans and projects are subjected to an appropriate assessment if they have are they likely to have significant effects on Natura 2000 sites. And those plans and projects, that term is project is broadly interpreted in the plan as well. It covers all renewable energy and grid initiatives in and around Natura 2000 sites, as long as they are likely to have significant effects on Natura 2000, which is quickly the case. You have to make an appropriate assessment, and mitigation measures can be taken into account in this appropriate assessment to avoid or reduce impacts or prevent them from happening. And the idea is that once you've done the appropriate assessments, then you can authorize the project, but you can only do that if the assessment establishes that the plan or project will not have significant effects. And important to mention is that the precautionary principle applies, which means that you can only authorize a project if there is no reasonable doubt left as to the absence of those effects. So it has to be high degree of certainty that such effects will not occur. And when there's doubt, the benefit will be of the doubt will be for the Natura 2000 site and not for the project. That said, just give you an impression of the process. This is taken from the EC guidance on Article 6. And it shows you that there's a kind of a pre-phase before you have to do appropriate assessment. There's a screening phase where you might avoid doing the appropriate assessment. But for renewable energy, this will not, in most cases or all cases, be possible. You have to do an appropriate assessment because those are not plans or projects that are needed for the management of the site. And they are very often, and in almost all cases, likely to have significant effects on the site. And likely means that there is a possibility that there is an effect. And if you cannot exclude that with certainty, then you would have to do the appropriate assessment. And the assessment is rigorous. The assessment requirements are rigorous. You have to assess the implication on the site's conservation objective. Also take into account the cumulative and in combination effects with other plans and projects. And if you cannot conclude on that basis that there are no significant negative effects, then you can only continue with the projects if you take enough mitigation measures to take away those significant effects, and that will normally require you to redesign the plan or project. And if you cannot do that, then authorization must not be granted. So it's quite a rigorous process, but it guarantees that the projects that are permitted are only permitted if there is certainty that no significant effects will occur. And then, of course, we get to the situation where that negative assessment is resulting from the appropriate assessment. Then you have a possibility to invoke an exception. And that's where we get into IROPI, because that's the exception that you might want to invoke if you have an imperative reason of overriding public interest. You can only do this, apply this exception after completion of the appropriate assessment procedure. That's always required. So you cannot skip the assessment procedures and go right away to the exception. No, first do the assessment, establish that their negative effects cannot be excluded, and then you can invoke an exception. And that's optional. It's not automatic. It's something that the authorities can decide on at the request of project developers, yes. But they don't have to follow this, so they can also say, even though if the conditions are not met, if the conditions are met, then that the exception will not be applied. It's also important to realize that this exception is interpreted very strictly. It's an exception and that should be applied restrictively. So in limited cases, not each wind farm will be able to meet the requirements and be able to apply this exception. In any case, in all cases, the cumulative requirements have to be met, and that is that there are no alternative solutions, that there is an imperative reason of overriding public interest, and that compensatory measures are adopted. All three of these have to be met. So just the fact that renewable energy is an imperative reason of overriding public interest doesn't take away the fact that you have to show that there are no alternative solutions and that compensatory measures are adopted. A little bit more about the meaning of the term IROPI, imperative reasons of overriding public interest. That term is used, but it's not actually defined in the directive, although it is clarified in the text a little bit which kind of interests fall within that definition. But there is some interpretation by the European courts, the Court of Justice of the European Union, and by national courts. And the Court of Justice rulings, which are decisive, establish that The reasons must be imperative. So it's, as I said, not every wind farm will be able to go through this procedure and show that they are imperative. The interest must be public. So it doesn't include just simple private interests. It must have a public interest at stake. And that, of course, that can involve private projects contributing to these public interests. But that is also quite strictly interpreted. And it must be overriding. And the fact that it's overriding means that it's a balancing between the interest at stake in terms of, in this case, renewable energy, and the interest of nature and the areas involved, and whether that overrides the interest of nature will depend on the situation. So you cannot say that in general. It will depend on the site, on the effects on the site, and on the projects itself. So it's quite strict also, the way that is interpreted by the European Court. In terms of what can be considered as IROPI, it's clear that the text already states that it includes interests of a social or economic nature, and that's quite a broad term. So even economic projects could fall within that definition. There is a specific requirements for Natura 2000 sites hosting priority habitats and species. Then the interest must concern human health and public safety or overriding beneficial consequences for the environment. That is to be decided by the member states, whether that falls in that definition. It's important in this regard that the European Commission appears to state that renewable energy, at least the grid initiatives and the ones mentioned in the communication, are public safety. So that would fall within that category. If you could not qualify it as such, then the EC would have to be asked a question, opinion, which is not legally binding, but it does indicate whether this is in fact IROPI and the project involved. Thus far, it's clear that most opinions have been asked for large infrastructure projects which did not meet the requirement of human health and public safety or overriding beneficial consequence for the environment. I think in terms of res and grid projects, it's safe to say that they qualify as IROPI and may be regarded as interests of public safety or overriding beneficial consequence for the environment, also considering that they mitigate climate change. But this will very much depend on the project. You cannot say that in generality, it will always qualify as such. You have to look at the project itself. I wanted to point out that the EC has never given an opinion on res and grid projects. Yeah, presumably because member states either do not use this exception for such projects, or they consider it to fall within human health and public safety or overriding beneficial consequences for the environment, and you don't have to request the opinion. Also looking at the flow chart here, that's again taken from the Commission guidance on Article 6. One of the things it makes clear is that it's a starting point is to look at alternatives before you go to IROPI. First of all, you have to look at other locations, other ways to implement the projects in a way that will not affect the Natura 2000 site involved less. Always start with alternatives. If there are no alternatives, then you look at imperative reasons of overriding interest. And depending on whether you have a priority habitat or species, you would have to invoke human health or safety considerations and important environmental benefits. Assuming that the answer would be yes, there are no alternatives, and there is an imperative reason of overriding public interest, then authorization may be granted, but always provided adequate compensation measures are taken. And the requirements for compensation measures are also rigorous. They have to be taken before the project is actually implemented. So they have to be adopted in time, and they have to be effective. So the requirements, in fact, they are outlined in the Commission guidance quite clearly. So I would refer to that, but understand that it's not an easy thing to go through this derogation process. Just to give you an example of a project that I am familiar with, that's Main Port Rotterdam. That's an extension of the Port of Rotterdam that involved land reclamation in a Natura 2000 site, a marine environmental site, and also affected some coastal habitats. The appropriate assessment was done. It was quite clear that significant effects on Natura 2000 sites involved could not be excluded. In fact, there would be clearly significant effects due to a loss of habitat. And that's why a derogation was requested and granted under Article 6.4 of the Habitats Directive, showing that there were no alternatives. The different project approaches and different land reclamation designs were examined and rejected for various reasons. Imperative reason of overriding public interest in this case was clearly socio-economic interest, development of the port, and compensatory measures were also included in as the part of the permits also that was granted through the creation of coastal habitats and large marine reserves. That was kind of the key three measures. That is the blue area that you see on the left below. That is a marine reserve within the Natura 2000 sites that was closed for bottom trawling fisheries. This was notified to the European Commission because it involved one priority habitat in 2002, and there was a positive opinion in 2003. So it took about a year to get that opinion from the European Commission, and the permit was granted for the project. And in fact, the project was completed and compensatory measures were adopted. Unfortunately, the compensatory measures were ineffective. There was no improvement of the habitat quality. That was the aim in the marine reserve. And that, that was very much to the disappointment of the non-governmental organizations that were involved. Also, at least they were very much aware and following this. And they have tried, we've had discussions with the Port of Rotterdam and the government trying to find a solution to make this marine reserve work. But unfortunately, we have not succeeded. And this has led us to bring the case to a national court. It's not ourselves, I should say, it's not just us. It's a number of NGOs in the Netherlands that wants to force the government to implement the compensatory measures as originally promised, which means excluding all bottom trawling fisheries in the reserve, which in practice was not the case. Only the heavy bottom trawlers were excluded, but in fact the number of bottom trawlers, shrimp fisheries, increased a lot and still causing damage, which is quite obviously the reason why compensation did not work. So there's no guarantee, even if you go through this procedure, that compensatory measures are effective, even though the directive requires that they are effective before the project starts. I don't know of any renewable resource projects that were the subject of this derogation for which a derogation was requested, at least not in the Netherlands. I know that one project of a wind farm, they did apply for derogation, but in that case, the court found that the alternatives were not at least established sufficiently that there were no alternatives. There was not enough evidence that there were no alternatives in that case to, for instance, like a different location. So not necessarily because it didn't meet IROPI. So just moving on to species protection, because that's where we looked at Natura 2000 rules, and those are the most well known, but in fact, IROPI also occurs in species protection. That's important because renewable energy can affect protected species. For instance, wind farms are the best example. They can result in the killing of protected birds or bats, or affect marine mammals such as harbor porpoise. And there might also be deliberate disturbance or deliberate the deterioration or destruction of breeding site or resting places. So at sea, I guess these three are the ones that are most relevant, at least the resting places at sea, not so much the breeding sites because they are on land. But they can be involved, and the prohibition apply to individuals of the species. That's very important to emphasize, because if you kill a bird, then you are actually violating this prohibition. Because there are similar prohibitions that are contained in the birds directive that also prohibit the killing of capture killing of birds, and also they apply to individuals of a perceived species. If that occurs, then you would need exception and derogation, and there is a provision in the Habitats Directive, Article 16, that provides the possibility to make an exception to these requirements, to this prohibition. The requirements are similar, but they're somewhat differently formulated from the ones that apply to Natura 2000 exceptions. In this case, also you have to show there's no satisfactory alternatives, very similar to what is in the Natura 2000 rules. You have to have a public interest, which is very similar also to the wording of Article 6.4, which mentions, again, the imperative reasons for overriding public interest, but also makes it clear that public health and public safety are among those. And it can also involve social and economic interests. And you have to demonstrate that the project involved is not detrimental to the maintenance of populations of species at favorable conservation status. So that's a little bit different from the one under the Habitats Directive Natura 2000 exception, because that says you have to adopt compensatory measures. In this case, it says you have to take measures to ensure that the project is not detrimental to the favorable conservation status of the species, which may involve adopting mitigation measures and perhaps also in some cases compensatory measures. But that's not what at least that's not specified in the directive. The Birds Directive has a similar exception. It doesn't refer to IROPI, but it does include the interests of public health and safety. And this is one of the things that came up in the Netherlands because we wanted to apply, the government wanted to apply the exception for wind farms, but Article 9 didn't refer to imperative reasons of overriding public interest. So they used public health and safety instead to justify an exception in that case. In terms of application of species protection, perhaps you have not heard about this that much because member states apply different approaches. Some member states consider that the killing of birds and bats by wind farms and other renewable is not to be considered as deliberate because the prohibition is on deliberate killing and capture of the protected species. Or individuals of the protected species, and they say it's not deliberate, it's incidental to the activity, it's not the intention to kill them, and it's therefore not prohibited. The directive does require systematic monitoring of incidental killing and also mitigation measures in cases where there is actually serious situations of incidental killing. Then you have to adopt measures to minimize that impact. That is done by several member states the differences were identified in this report that you can see on the left, renewable energy projects and species protection, which looked at the way the Netherlands, the UK, Belgium, and Denmark and Germany apply these provisions. And well, the differences are considerable. And the Netherlands is the one following a quite strict approach. They interpret these provisions quite strictly. They say deliberate also covers conditional intent, and that is based on the jurisprudence of the European Court of Justice on these cases, which says that it's not just when you deliberately, when you intend to kill a bird or another protected species, that there is a violation of prohibition. It's also when you know or should have known that this might occur or is likely to occur. So that is in fact also more situations, and with wind farms in particular, and many other activities as well. You have the information, you can expect that protected individuals of protected species will be killed, in particular if you put them at the wrong location. So Netherlands does apply this quite strictly and issues derogation for most wind farms, which is particular because I don't think any other member state does this. And the EC is quite critical about this approach. And that is also understandable because these are exceptions to the general rule, and exceptions should be used restrictively and not for every wind farm, for every product. They should be used in exceptional cases. And this is, I guess, a way to apply it almost to a whole sector, which is probably not what the directives intended. In any case, thus far, the Dutch courts have followed the approach that derogations are required. So we are looking, in fact, the government is looking into a different way to do this, applying more the approach of other member states by looking at mitigation measures and combination of monitoring of killing to minimize impacts, rather than just applying derogations for each and every wind farm. The way it's done in the Netherlands currently with regard to offshore energy, and that's what brings me to the Dutch approach in the energy transition in the North Sea, is that we have kind of streamlined the permit procedures for offshore wind energy. There's a separate act for this, the Offshore Wind Energy Act, and that provides the basis for what we refer to as wind farm site decisions. There are legally binding decisions that also incorporate Natura 2000 permits and species derogation. So it's I guess it's an instrument that collects the key environmental permits that are required for wind farms. Each site decision addresses the condition of the Birds and Habitats Directive. So they are in accordance with the requirements of the Birds and Habitats Directive. They are based on appropriate assessment if it involves Natura 2000 sites. They also look at effects for protected species in the context of the framework for assessing ecological and cumulative effects. That is to establish that they stay within the limits, that no deterioration occurs of the favorable conservation status of the species, one of the conditions that applies to protected species derogations. IROPI is applied also in these decisions and public health and safety for birds for species derogations. They are only, that's what I mentioned earlier, that the Dutch approach is quite strict in terms of species protection. They issue species derogation and the purpose is, the interest involved is IROPI and public health and safety, not for Natura 2000 because it's not necessary, because the appropriate assessments establish that there are no significant effects that will occur. And I'll explain a little bit later why that is. But so far there was no reason to resort to the application of RePowerEU for Natura 2000. So no application of Article 6.4 of the Habitats Directive has been needed for the wind farms at sea. In all cases, the site decisions include certain mitigation measures for bats and birds, including curtailment requirements, as well as also specific measures for migratory birds. But yeah, they do include mitigation measures to minimize effects, basically, of the wind farms as much as possible. These wind farms site decisions, I've looked into it, they take about 2 years to become final. And if you think about the construction, actual construction, I think takes about 4 years. So all in all, it takes about 6 years to have these permits and go through the whole process of just construction. So 2 years, I guess it's the quickest way you can do it. Of course, you cannot see this in isolation from the whole maritime spatial planning. The Netherlands has an elaborate maritime spatial planning process. We've done that for quite some time, and recently we have adopted a new spatial planning program for the North Sea. That's North Sea Program 2022-2027. One of the things it does, and you can see that on the map, is that it identifies existing and new offshore wind farm zones for the period up to 2030. Those are in red and orange, the sites. And importantly, and that's one of the things that we have pressed for, is not to have offshore wind farms in protected areas. So far, none of the wind farms are in the Natura 2000 sites or in the marine strategy framework protected areas, because there's also some that have been designated for that purpose. But that makes it easier, of course, to grant a permit for those under the Natura 2000 rules. As I said, appropriate assessments were done, because you have to do an appropriate assessment, not just when you're constructing wind farms in Natura 2000 sites, but also near Natura 2000 sites. And they may affect, of course, the species that migrate from and to the sites. So that was the subject of an appropriate assessment, and found to have no significant effects, at least thus far. The whole selection process of offshore wind farm zones is based on an integral approach that looks into all interests involved, and not just the ecological consideration, although they're very much a part of that process as well. So even if they're not in Natura 2000 sites, the ecological considerations are still taken into account. And sensitivity mapping is also part of this process. But of course, they also look at other interests, such as fisheries, which are equally treated in that process. It's an adaptive process. The fact that energy zones are identified doesn't mean that the actual wind farms will be constructed in those areas, or precisely where they will be constructed in those zones. That is determined at a later stage based on the data that is collected. And in the end, once the decision is made to build wind farms in those specific zones, then the actual site decisions will determine precisely how the wind farms will be constructed, and what type of turbines and what kind of measures will be required, also to mitigate the effects on nature. So that is the current process. We're actually looking already beyond 2030. And there have been some other sites identified in the Dutch part of the North Sea for offshore energy development. And all of them are still located outside Natura 2000 sites, which is in agreement with something that I have worked on that was mentioned earlier. It's a North Sea Agreement that was adopted in 2020. It's a national agenda for North Sea policy up to 2030, also looking beyond that. And as I mentioned earlier, it facilitates energy transition, but also the food and nature transitions, and contains actions for each of these transitions. Of course, for the energy transitions, it's mainly aimed at increasing the amount of wind farms at sea, but it also has a food transition and a nature transition. And in relation to the latter, one of the things that is included is, for instance, designation of more protected areas, development of species protection plans, and also nature inclusive projects, project development in the context of renewables in particular, so that nature benefits, might also benefit from these wind farms that are constructed at sea. The agreement aims to avoid conflicts between stakeholders. It's important to understand that this is not just a government thing, it's very much a process where all stakeholders, key stakeholders are involved. That's the energy sector, the environmental NGOs, as well as the fisheries sector, although that was somewhat resistant to participation. But now we have a permanent North Sea consultation, which includes all key stakeholders, including the fisheries sector. And they meet regularly, also looking at all developments to make sure that, well, the process is balanced. So it's a balanced approach for all transitions. There's a comprehensive research monitoring program in the transition fund, but I won't go into that. It's well structured, but implementation is, I should note, it's a challenge, because the energy transition, there's a lot of pressure to speed up the process, but we don't see the speed in the nature transition. So it's, in particular, when it comes to excluding fisheries from protected areas, which is a very sensitive issue. But that we don't see the promised progress that was in the North Sea agreements. So there's work to be done. Just by concluding, to answer the questions, qualifying RES and electricity grids as IROPI under the nature directives is one of the conditions to make an exception to the area and species protection rules. But as I mentioned earlier, that still requires that all other conditions are also met, that there are no alternatives, that compensation is secured for when it relates to Natura 2000 sites, and also for species protection, the requirements are very similar. The application of IROPI to RES and electricity grids under the directives, I don't think it will speed up the permitting process, simply because procedure for making exception is rigorous and time consuming. It's also not a way to sidestep the planning and assessment requirements under the EU directive, nor under other EU legislation or any legislation, international legislation. You have to go through these steps in any case. And that's why I would say the preferred option is to prevent the need to use these exceptions in the first place by following a structured spatial planning process. And I get the impression that this is also something the European Commission wants, because you can see in the RePowerEU communication, it doesn't just mention that we have to speed up the permitting process, but it also makes clear that we have to identify suitable areas for renewable energy projects. And as the communication also states, that the Commission will propose in the upcoming nature restoration law that member states should identify the go-to areas, clearly defined areas that are suitable for such renewable energy projects, while avoiding as much as possible environmentally variable areas. And they can use the review of plans under the Maritime Spatial Planning Directive to further deployment of renewable energy projects. I would say that that's precisely what the Netherlands is doing. Okay, that brings me to the end. If you want to know more, there is a lot of very good information in the EC guidance documents I would like to refer you to. I've just mentioned here some of the key ones, and our position paper, the BirdLife position paper, that also provides a very clear process of how to do this in a nature-friendly way, the energy transition.
Thank you very much, Harm, for this very insightful presentation. So that we have lots of food for discussion now. It's we have lots of elements, and I see already that there is some conversation going on in the chat. First of all, I mean, I would like to thank you, because actually in your presentation and your conclusions, you answered to the guiding questions of this webinar, whether actually the application of the imperative reasons of overriding public interest would actually speed up the implementation of renewables and grid, so that you're telling us that in your experience and from your perspective, this does not mean that this will happen, because there are still some requirements and there is a procedure in place that takes time. So that this is one of the main outcomes that I see from your presentation. I also see that so there is, as I said at the very beginning, introduces this session next week on the May 18th. The Commission will actually publish these guidelines for permitting of renewable energy, so that further guidance will be given, and also more clarity will be provided on these possible derogations under the overriding public interest. I see from your presentation it is a very good point, and the point being that, of course, we should not reach the point of invoking the overriding public interest, so that there is much more can be done before. And the example of excluding, for instance, the Natura 2000 areas in the case that you just brought is a very good example of how not to end up actually having longer procedures afterwards, so that by addressing before the main problems. So I see that there are many questions I would like to ask. First of all, I see already some of the participants have been very diligent and they have put the video on, so that I would ask all the participants to put their video on, please, so that we can have we can see your face while passing you the floor for the questions. And so that so let me just rephrase some of the, to bring to you, Harm, some of the comments that I already saw in the chat, and then I will pass the floor right after to the one that raised their hand. So today we talk about the nature directives, and we talk about the bird and habitats and bird directives. It was mentioned that the case of the water directive, so that we understand that for the water directive there are different implications, and this is very important also for the discussion about hydropower. That so that when we refer to renewables as renewables that actually have a potential to we have a potential of reducing the impacts, but renewables that actually should be pushed, and we refer to solar and wind. But of course there is also another part of discussion that goes along with the hydropower and biomass. And when you show us actually this scheme that the Commission is applying on whether you can justify the implementation of a project with the environmental benefit, and the environmental benefit maybe most probably being also the reduction of emissions, as most of the time it is interpreted, that this would not apply, for instance, in the case of biomass or in the case of water for other impacts. Do you want to reply on the water directive, Harm? Do you have any specific insights on this, or I mean, as we have discussed, it's more about the bird and habitats today.
Yeah, it's I focused on the Birds and Habitats Directive. I didn't really look into detail into the Water Framework Directive, but that's an obvious candidate. Marine Strategy Framework Directive possibly also. They do include exceptions, which have, well, they also have other conditions than just the IROPI requirement. But I didn't really look into that into detail. So.
Okay, yes, as I said, the focus of today was actually the other two directives. There is a question about, a very quick one that I would like to address, about the requirements that you have presented for the requirements, the three requirements being the no alternative solutions, the IROPI, and the compensation measures. So the question is whether these three have to be met, all of the three, or one of them.
No, yeah, so it's all of the three. That's, I guess, essential points, because that just stating that it's IROPI is not enough. You have to show there are no alternatives and that compensatory measures are adopted.
Okay, thank you very much. And then I see some other comments that I would like, then it's a little bit more on feedback rather than questions that I would like them to ask those who submitted this in the chat, maybe to raise their hands so that they can also join the conversation. So I will go now and ask those who raised their hands. I hope that I'm calling you in the right order, but I will start with Lucy Quinn. Lucy, please, can you also tell us what's your organization, and then, yeah, the floor is yours.
Yeah, thanks very much. Hi, Harm. Thanks very much for the talk. I'm Lucy Quinn. I work for Nature Scot over in Scotland. Yeah, I was really interested in your talk, and my question relates to if what happens when compensatory measures don't work. So you gave an example there within your talk, and you mentioned that case is being brought to court, but I just wondered, is there any other information, or have you any other examples from on the continent where the compensatory measures haven't worked, and is there something that, you know, something in law or something that developer then has to be able to do in order to try to make that work? Or is it a case of, because it's been consented then and potentially constructed and everything, you know, what can you do at that stage, I suppose? I'm wondering if you have an example.
I think there are many examples, but I on the top of my head, I'm just thinking about the one I am very familiar with. It's the main port Rotterdam, and I think the Commission is also quite clear that if compensatory measures are not effective or not adopted, then it has to be done, or the permit might be withdrawn, or the project has to be halted. Obviously, in many cases that is no longer possible. It would mean for instance, taking away, if it's a wind farm, taking away the wind farm, which is, I guess, a costly thing. But the compensation requirement remains in force. So it's not like you can have the permit, so you can just forget about it. That's precisely why we take this case to court, because we want those measures to be effectively implemented. But on the top of my head, I can't think of an example now that I know. I think what I do see is that compensation measures are not always effective before the project is implemented. And I guess the Commission is a little bit lenient on that in that respect. If the expectation is that the results will come, then they will allow it. But strictly speaking, it should be effective when the project starts. And I don't think in many cases that's the case. So.
Thanks very much. And yeah, I can imagine it's quite hard to actually measure that as well, especially if you're talking about birds. You know, how can you measure it in that time period? So yeah, thanks very much for answering.
Thank you very much, Lucy, and thank you, Harm. And I mean, this question also relates on how to proceed when we don't have sufficient data, and so that it's the dilemma of how we boost and we speed up the renewables, but at the same time we still need research. I mean, and we need final results. So that this is the dilemma between the two things. Thank you very much. And I will pass the floor to Jonathan from WWF.
Thanks. Yeah, and also thanks, Harm, for the very, very interesting presentation. You mentioned this requirement that there is no satisfactory alternative, which is basically an additional requirement to the overriding public interest. And I'm wondering, how does that relate to this go-to areas that you now also mentioned in the last bit of your presentation? Basically, would it be enough? I mean, this probably affects the species protection rather than the Natura 2000, because that's hopefully excluded from go-to areas. But would it then be enough that a wind farm or a solar park is located within a go-to area that it can claim that there's no reasonable alternative? Is that enough to fulfill this criteria? Thanks.
It really depends on the situation, but I think one of the ideas of these go-to areas is that's the areas where you want the renewable energy to be constructed. So that would be an easy way to show that there is no alternatives, because these are the go-to areas and there are not that many alternative locations. But of course, it still has to be demonstrated in that process. I assume that the go-to areas will not be Natura 2000 sites. So then you would not
this
probably need
demonstration,
you don't need a derogation, at least not under the Natura 2000 rules.
But how long does this take, this demonstration that there's no alternative? Because is that something that could be speeded up by saying everything that is within a go-to area, and we have low environmental impact, and then therefore we can assume that there is no alternative, and this might prevent, I don't know, a half-year analysis of different alternatives. Yeah,
it might. It depends on whether that would stand up in courts, because the idea is that for each project is an individual examination is done of the alternatives, and just by giving a blanket indication what is that the go-to areas, and that there's no alternative to that, it's probably too easy to say for all renewable energy projects. But yeah, I think it might be used in that context, and might speed up the process, at least from the alternative research perspective.
Thank you, Harm, and thank you, Jonathan, for the question. So that the demonstrating that there are no alternatives, of course, it requires also that the criteria are defined for the no alternatives, so that what are the prioritization that we give, so that each time a project actually is presented, that there is already usually an analysis of the alternatives, and so that usually the project should be the best option among alternatives that have been already considered, so that it would be interesting also to understand even more what the criteria are in order to define these alternatives. But thank you very much for this point. I see the hand raised, David from BirdLife Spain, please.
Hi, thanks for this session. Really timely and useful. And Harm, I really enjoyed your summary. Very clear and helping us to look to the future as well. And that's where my question comes in. You were talking about the Dutch government looking already out beyond 2030 and how to address this area offshore. I wondered if in that work in the Netherlands, you're looking beyond just the wind technologies. Along that time scale, maybe we'll see more technologies, offshore technologies, reaching market readiness and commercial viability. So I wonder whether within the Netherlands or in other countries, already looking to the future, there are real scale options in these other technologies coming forward.
Well, I would say yes, but the focus is mainly now still on wind farms. We do look a little bit also at the solar energy at sea, development at sea, in wind farms, but that's just a minor part of it. And the thing with the North Sea Agreement and the North Sea consultation that we have, it's a flexible process. So new developments will come in and will be discussed in that context. But the emphasis currently is very much on wind farm development.
Thank you, Harm, and thank you, David. I see another hand raised by Antonella, RGI.
There was someone else before me, but good.
I cannot see it in case, just ask my colleagues to let me know in case.
Yeah.
Antonella, go ahead, please.
Yeah, thank you very much. I have a question which is maybe a bit more broader. In relation to these go-to areas, it's clear that there is a strong push to define where to go with renewables, especially solar and wind, and an incredible need to add capacity, energy generation capacity as fast as possible to reduce dependency of fossil fuels. One of the key challenges that I think is in the thinking of these go-to areas and the MSPs and all the planning, is that usually the planning is done with a very short time horizon, even if it's 10 years, a short time horizon. And so what do you think should be needed to define the areas so that we can reach full decarbonization? Because at the moment, we basically define where to go for the next 5 or 10 years. And we may skip the Nature 2000 areas, but we know that more space will be needed for the next step. And so a one choice now will prevent further development later. And I don't know whether you have some thoughts about it and whether they are reflected in the legal thinking. Thank you.
That's a very, very, very good question. Honestly, I don't know the answer because I'm not closely enough involved in the go-to area and development. I know that they, of course, should be sites with the lowest impact on nature, but there is I'm not sure how that would fit into the idea that we restore areas also that have been degraded, but perhaps that are currently maybe suitable locations for renewable energy, but not the areas that we would want them because we want to develop nature there. But perhaps one from BirdLife can say a little bit about that. Raphael, maybe.
I mean, just want to comment, it's a bit cynical because there is not such thing as a go-to area development. It is all drafted very, very spontaneously. I mean, that is the contrary to good or better regulation. I mean, what we see right now here is that because of the pressure, the political decisions makers think to need to react to because of the Ukraine war. They don't take the time for good regulation, but they just come up with an idea which was planned. I mean, to make it more and more pictorial. The idea of go-to areas was first of all mentioned in the planned nature restoration law, and the restoration law is even not out presented by the Commission. But now you come with the area and in the new legislation which comes first. So I mean, the go-to area was the idea to have proper sites for nature, and then on the other hand, proper sites for renewables. And now we only start with the sites for renewables without having the sites for nature. And I mean, the linkages, the DG Energy just had a few weeks to come up and needed to convince that they cannot I mean, disregard all also international law provisions like from the Aarhus Convention on Public Participation, or the consequences for the environmental impact assessment, which are huge. I mean, there is a lot of consequences, and they are not thinking about that. They are just trying to come up with a quick solution to show action. And I mean, that has to be criticized, but there is no further thinking for the future yet. And that's why we are here, and that's why we are trying to at least make sure that we take the time for all the nature protection interests as well.
I would like to add to this, because on one hand, I understand this argument, but I also hope that by defining the go-to areas, you automatically also define the not-go area as a joint exercise. It is not going to be necessary like this, but I think it could be like that. And the other thing I want to add is that we are indeed in the middle of a huge energy crisis, which we will feel definitely going ahead much more. And so I think every actor has to realize that somehow we need to find solutions. What these solutions are may not be clear today, but the energy crisis will be disrupting European life and European values latest by winter, if not earlier. And it is already disrupting because we are paying Putin every single day billions, and we continue to import gas. Personal thinking, sorry.
May I just add something? I don't find the button for raising my hand. I know there's Rafa Seitz has raised his hand before me.
So yes,
but I don't
I pass you the floor, and then I will pass the floor to Rafa because he was there. But please, if you want to react, maybe Rafa, just pardon us a minute, please, Reinhard.
Okay, thank you very much. I work in the legal department of 50 Hertz, the TSO in one of the 4 TSOs in Germany. And we are faced also with the problem to connect all these wind parks onshore and offshore to our grid. That means we do not only talk about accelerating the construction of wind parks, but of course you need sufficient grids to connect them also. And in general, you can say that the durance of the permit procedures for our electricity lines is much longer than for wind parks. So if I hear something about go-to areas, I'm very interested whether these things can also work for our electricity grids. And I must say, I doubt whether this really works, because if you have an electricity line which is 100 kilometers or longer, let it be 50, it's very often not possible to completely avoid protected areas. You will cross them anyway. So you have to find solutions also for these cases. Go-to areas, we have that in Germany as well, for the wind parks, especially in the spatial planning. This is a concept which is long established. And to establish such go-to areas, it takes also a long time. You have to, the planning authorities for these go-to areas, they really have to work on these things for years. There's public consultation, and it is not a quick win to introduce and to ask for go-to areas. That's what I think. This was one thing I wanted to add. And the other thing is, of course, we all want an intact nature, but on the other hand, we want faster procedures. And to be honest, the nature law is the major obstacle for fast procedures, because as a project promoter, the most part of the planning, the time goes into preparing environmental assessments and doing them in such a way that they will be held up by the court, because of course there are many NGOs which are challenging the decisions in the end. So after 10 years of planning procedures, you end up in court, and we are faced with a lot of insecurities in the nature law, and many of them have been addressed already. For example, the alternative checks. How far do we have to, how deep do we have to go into the alternative checks is unclear so far. It's not cleared by the courts so far. How far does this rule of excluding any reasonable doubt have to go? If we don't know exactly how a specific bird will react to an electricity line in certain circumstances, we really face problems, even if we want to do the best for bird life. We simply don't know anything about these. We don't know all about these nature issues, and even bird protection organizations cannot help in any case. So it's difficult if you have such high standards, like excluding any chance or any possibility of doing harm. Then yeah, that's a really difficult thing. And the last thing is, I want to mention yeah, how to deal with these insecurities. If you end up saying, okay, maybe 95% of birds, for example, is for our lines the most important issue, 95% you can really prove that there is no reasonable doubt that there's no significant adverse effect, that's fine. But for the remaining 5%, what are you doing? You can, then of course you can try to argue, and you can take measures to try to reduce. And these measures have to be effective, but if you're not sure about whether they are really effective on any single bird, you end up having a legal insecurity. And then, of course, you can try to go for an exception, but these exceptions are difficult to get. And of course, if you claim it is an exception, you also state, I'm not really secure about my assessment in the first place. So in the end, you end up with a lot of insecurities in a complex project. And I haven't heard so far arguments how we can get rid of this, of these insecurities. And I think this is something we need to face more, and to go for this challenge, how to get rid of these insecurities in this Natura 2000 law and the Birds Directive law. Otherwise, I don't think that we will reach any accelerations, and the go-to areas will not help us. And the IROPI concept, I fully agree, will not help us in accelerating. Sorry, that was very long.
Thank you, Reinhard, but this is, I mean, very interesting, of course, input to the discussion, because it's also the perspective from who develops the infrastructure and has some question and insecurities that needs to be addressed. I do not have myself, of course, the answer to your questions, but I would open the floor then, I mean, also the reaction to the points that Reinhard has just raised, as they go beyond, as you were just saying, the application of the overriding public interest, but actually are part of the process of construction of an infrastructure. So I would first of all ask if there is any reaction to this.
Yeah, I can say a little bit about it. It is, I guess, it's the regular procedures that are already a problem, in particular for grids construction. I realize that it's probably an activity that cannot always avoid going through protected areas. In terms of alternatives, well, one of the things that we promote is having power lines underground rather than just on the surface. That is costly, but that's technically feasible, and particularly if you limit it to the areas where the likelihood is the highest that the bird strikes might occur, or other negative effects might occur. So there are mitigation measures that you can adopt, I think, or just look at alternative project design to limit the effects and stay within the required excluding significant effects, because it's not that nothing is allowed. The significant effects should be excluded, and that of course depends on the site what that means and the conservation objectives of the site. But there's room for some impact, not zero impact. One of the things we do in the Netherlands, we have there's always a kind of a limited, in certain cases, a limited uncertainty remaining as to the effects, and that the courts have established that can be covered by monitoring, using monitoring and an adaptive approach, basically, that allows you to adjust the measures if needed. In terms of grid initiatives, I'm not quite sure how that would work, but and that's at least one of the things that was accepted in Dutch courts. But then we're talking about a limited amount of uncertainty remaining, and not just general uncertainty, or when there is actually the likelihood is very significant that damage will occur.
Thank you very much, Harm. So I I will pass the floor to Rafa because he raised his hand. Rafa, I know that you had a question before. Maybe you also want to reflect on the point that has been
I was not planning to respond to Reinhard, but I'm in the obligation to do so as WWF. I mean, from my view, it is absolutely clear in the legislation what it has to be done. The other thing is that, as Harm was saying, it is costly. It is difficult to think about it because it's better to think about their own projects and the own economic benefits of it. But the legislation is very clear, and it's a preventive and precautionary principle before taking the negative impact. So I don't agree with that approach because, for the most part, member state has done it in the same way. No, they say, I'm going to do this, whatever renewable project it is. And what I present is slightly different alternatives to say what I can do and try to justify, but not really thinking from the beginning if this is needed and this is something that has to be changed or not. And that's one of the problems. It's not in the legislation, it's rather on the implementation of the legislation. But apart from that, I was really impacted by the reflection of Antonella and also Raphael on, do we really need all these new renewable projects? I mean, within this approach of, okay, let's go renewable 100% whenever, have we ever stopped think about the need of this energy? Because I don't see that much debate and discussion about reduction of the use of energy, go to another solutions more focused on the local and not building bigger and greater grids. And from my view, and now I'm not an expert on these projects, but I work on water and I see the same for the consumption of water or hydropower as it is. And I see the same lack of discussion about the need of providing so much energy, so much new renewable projects. And I don't know if within the legislation or within the group that is present in here, somebody has think about the need of doing so much acceleration for this. Because maybe with reductions, with adaptations, with another way of doing things, it might be feasible to not really need to accelerate more renewable energy projects. And I don't want to left this question as something coming from the ecology sector saying we don't know economic development. I just want to raise the question because in Spain, for example, we are seeing that a lot of solar plants are planned, proposed, and so on, without any thinking of if there is a need for such an amount of energy. And we put all the focus on the environmental restrictions and problems that might come with all these projects. But we are missing since the beginning the reflection of, do we really need this much energy or not? No, and that's my reflection and also question within, this is considered within the legislation, the prescription, or the plans for the development of these projects. Thank you.
Thank you, Rafa, and thank you for bringing, I mean, of course, so this is a key topic, the complementarity with the reduction of energy consumption, so that it's, that goes along with the discussion with renewables, so that both are absolutely relevant. Of course, we will need to address this with the Commission at the moment and then with the member states, but of course, I mean, we do recognize that this is an important part of the conversation. I would pass the floor to Antonella because Antonella, you opened this point before, so that I would like you to answer to, or to provide, I mean, further feedback on this point.
So before answering this point, I want to mention something about undergrounding, because we have believed for many years that undergrounding of electricity cable would be the solution to avoid environmental impact. But there have been studies, including from NABU, that showed that actually also undergrounded has some types of impact. So I would like everyone to be aware that whatever we build, we do have impacts, and the real task is to optimize the way we build and the technologies we choose, not only from an environmental point of view, but also from a technology and an economic point of view. It doesn't mean that the additional costs that undergrounding brings is not possible. Actually, in many cases it is, but sometimes the technological challenges are not possible. And sometimes the environmental damages of undergrounding can also be not acceptable. So there is not a blank check for anything. Very often when people talk about undergrounding, they refer to birds, but there are other species and other environmental factors that also need to be taken into consideration. So this is about undergrounding. Now, let me go to the big question of Rafa. Do we need this energy? Well, we need a lot of energy. But at the same time, you are 100% right that we need to reduce our demand. And there are different studies and different ways that shows how to do it. The PARC project, it was mentioned in the chat, it's really showing that we need a lot of energy, but we can reduce our demand of energy if we do deep electrification, if we optimize the use of assets, and if we also optimize the architecture of the energy system. Nevertheless, if we want to decarbonize, it's not possible to decarbonize only with rooftop solars. And this has been proven over again. And I hope that this energy crisis that we are in will bring a massive saving. I don't see this happening yet. I don't see governments and politicians talking about saving, but rather only about reducing electricity prices, which is, I think, not ideal. But in the big oil crisis in the 70s, we had a huge efficiency gain across all industries. There is a limit to what efficiency we can add to that major development, but saving is an untapped source, but it is linked to our lifestyles. It is linked to the way we live, the way we consume, the way we produce, and where we produce. So I think we should not take much more on this subject. We can organize a separate discussion on this because it is very, very important. But now we do need this massive expansion of renewables, because if we don't get renewables, we are going to make deals with other dictators around the world, and we continue to fuel a war. And of course, we burn planet Earth. Thank you.
Thank you very much, Antonella. As Antonella was saying, all these topics are, of course, related. Today we just focus on one aspect, and unfortunately, we have a few minutes before we need to close. So I still see a hand raised, but I have to say that I need a very succinct and short feedback from Alice, so that then we can conclude and thank all. And you are on mute. Let me see if I can unmute you. Yeah.
Can you see me? You hear me?
Yes.
Yeah. I work for transmission system operator, and we are part of the regulated part of the energy sector. And we see that the cost of the cabling and cost for the mitigation and compensation measures, costs are increasing fast, very fast. And the question is, when we collect money to make this cabling and the mitigation compensation measures, do we really make better for the environment? Because we must know that for this cost, we must activate other energy, other sectors of the other sectors to produce new value to cover these costs. But this industry has also impact on the environment. Do we really make a profit or reducing impact when we cover costs for the regulated part, with producing additional pressure on the environment with the activity of the industry who produces this additional value or added value. Can you understand my question? That means industry might be activated more to cover costs to build a new infrastructure.
Yes, so that you mean
a
really
negative impact on environment. Thank you.
Okay, so you Alice, I'm just rephrasing, but you mean actually not having this burden on citizens, but actually having the industry contributing to this additional cost by itself, so that I mean industry actually covering the cost of the environmental impact and measures that need to be implemented, if I'm not wrong. Which I don't know if maybe just to conclude, if Harm, you want to give an answer on this aspect of the cost of the environmental measures that need to be taken, and then we unfortunately really need to close this.
Well, just a very short answer is that it is the project developer who has to pay for the compensatory measures to be implemented and the mitigation measures to be adopted. So it's not that the government has to pay for that. In certain
we don't
cases,
understand.
Yeah.
When we see the whole system of environment, we on one side, we activate industry and make harm to the environment to cover the cost for the regulated for cabling or something like that. That means we don't, on the level of the whole system, we don't see if we made with the mitigation measures on the regulated part of the energy sector, make less pressure on environment as we did it with the industry who produced additional value to cover this cost. That means of the whole economy, not just the producer or just the one company. It means of the whole sector or the whole global system.
Yeah, but that's a regulatory issue then.
Yeah, and then we are entering into the regulated and not regulated businesses, so that this, I mean, requires a further discussion. But thank you very much, Alice, for raising this question, and we will try to address it in the future conversation that we will be having. So I still see that there is a lot going on in the chat, and we will download the chat and try then to understand if we can further answer to your questions. I would like to thank you very much, Harm, for this very insightful presentation, but also discussion, and thank to all the participants. You will be receiving the presentation and the link to the recording available just for you participating today. And thank you, and have a very nice day.
Thank you, and have a nice day too.
Thank you.
Thanks for organizing. Bye-bye.
Thank you for this organization. It was great.
Important topic. Thanks.